Hi, everybody. Welcome to our Small Claims Court for Creative seminar. We are doing this today because we started noticing a large number of similar questions from especially the musicians community that Pat is a part of. And we've never done anything like this before, so we've got a lot of people today, which we're really excited about. But you will also have to bear with us because we've never given this presentation before. It might be a little more disjointed than usual, but this is us, and we are Texas Accountants and Lawyers for the Arts. I'm Angela Lee. I am the legal director here. I've been with TALA for 11 years as its legal director, 10 years as its legal director. And it's actually been around since 1979. And we are a nonprofit we consist of around 300 active attorneys and one CPA who provide free services for artists who qualify financially. So you would have to be under 300% of poverty level, which is actually pretty generous. And that would entitle you from time of application to 1 year of unlimited requests for services. And so you can actually get an attorney for direct representation. Like you would actually be signing a whole engagement with an attorney to negotiate contracts, to help you mediate something, to help you register a trademark, to answer infringement claims and things like that. And we love what we do here. We love the people we serve, and we're happy to have you. With that, I'm going to introduce Brian McGivern, who is with Austin Community Law Center. And Brian, why don't you go ahead and tell us what you guys do?
Sure. So, as Angela said, I'm the executive director of the Austin Community Law Center. We're a nonprofit law firm. The easiest way to explain it is that we are similar to other law firms in that people hire us to do stuff for them, but we're different and as a nonprofit, primarily in the sense that we charge a lot less. So, traditional legal aid, which represents people for free, does very good work, but they have a very low income threshold to be eligible. It's 125% of the federal poverty guideline. We go up to 400%. We do charge on a I think I mentioned charge on a sliding scale based on the client's income. And we're a general practice, so we pretty much handle kind of anything that's likely to walk through the door.
And so the reason we've asked Brian here is because the difference is that TALA does not litigate. So this is a kind of natural, progression. We can help you until you actually need to go to court. And then Brian would be the expert in all things self-help, court related, and also representation for court. And then we have Pat with Austin, Texas musicians. And as I said, it was through this Austin, Texas musicians. I think about a third of you came in through this group today. I noticed that there were a lot of the same kind of cases or case requests coming in. Having to do with venues that were chronically not paying. There's a lot of them, so I'm not talking about one in specific, and contracts in general that were being breached. So why don't you tell us a little about what you guys do, Pat?
Sure. Thank you so much, Angela and Brian. It's great to be here. Yeah, Pat, with Austin, Texas musicians, we've been around about 7 years providing advocacy, policy representation on city, state, federal policy that affects musicians and also economic development and education. We've been very fortunate to partner with TALA that entire length of time. We've been able to provide some great services over the years to our musicians, and I know that we have a lot of musicians here today because of a lot of different recurring questions that continue to come up in our community. So we're just happy to be here. Also want to just recognize that there's some other great music industry leaders in the room today. Aaron Lack, president of the AFM 433. If you guys don't know about the union here, y'all should check it out. Jake Davidowitz, another great entertainment attorney in town, because I think there's what, five or six of y'all total. And beyond all that, we're just super happy to be here. This is a really, really important topic. And just as we always say, legal is often the last thing that musicians think about when it should be the first thing. So happy to be here.
All right. And with that, we are going to move on. So today, this is kind of what we're going to be discussing. We're going to try to follow this point by point. Just look over that real quick. The distinction that I want to make is that if your issue is with your employer, for example, if you were drawing a paycheck and you were salaried, this might not apply to you as much, but we will talk about that briefly. Um, and this will also probably not apply real well to people who have some sort of dispute over the ownership of intellectual property. Those are separate remedies as well. So this is mostly for payment for contract work that you've done. Brian, do you see any other distinctions that should be made so people who are in the wrong room can exit gracefully?
No, no, I think that's right.
Awesome. All right, so as I said, Brian's kind of the expert here, so we're gonna let him take it away.
Okay. So, and just as a reminder, as we go, if you have any questions, feel free to throw them up in the chat, and I'll do my best to see those and respond to those in real time. So, employee versus independent contractor. Um, the short story is that employees have more rights vis-a-vis the person paying them than an independent contractor does. Whether or not you are an employee or an independent contractor depends on the circumstances of the work that you're doing. And I say that misclassification where an employer decides to treat someone as an independent contractor is a pretty common problem. And it's not every person who's hiring somebody else knows that they're misclassifying them. There is a very common understanding that if you just send someone a 1099, for the work that they've done, then that makes them an independent contractor. And that's not correct. The distinction depends on the circumstances of the employment. An easy illustration of that, there are a number of factors, but an easy illustration is like if you hire a plumber. I just had a guy who came out to my place the other day to replace the washing machine. He is an independent contractor. He is not my employee. Uh, if I owned, I don't know, a hotel and I had a maintenance person who worked for me full time, they would be an employee. The factors, when there is a dispute about whether the nature of a person's relationship with someone paying them, there are factors that a court would look at. They look at whether or not the worker's business, if has like levels of independence, like you do your own advertising, do you pick up your own clients, who's furnishing the tools? The plumbers, when they showed up at my house, they brought all the tools. I don't own any. Whereas, and I think the same would apply to most music performances if you're being hired to do that. Whereas, like if you're a house performer and you show up and they're giving you instruments, then that could be different. Another factor. None of these provide a clear line. They all kind of go into a mix, and you see how it works out on balance. Another is control over progress of the work being performed. A maintenance person working at a hotel would probably have fixed hours, and they would be directed in detail in the work that they do. Whereas, as we know, people who we hired, as plumbers or whatever, they give you a window of time, and maybe they'll be there in that window, and maybe they won't. But you don't have the right to control that necessarily. Also, whether the work is for a finite amount of time or if it's continuous. So there are a number of factors that go into it. Ultimately, it boils down to the level of control that the person is exercising. The person with the money is exercising over the person performing the service. Why is it important? Well, if you're an independent contractor and you do work and you don't get paid for it, your remedy is a breach of contract action. If you're an employee, well, one, you can sue for breach of contract, but you have additional remedies. You can go through the Texas Workforce Commission, for instance, and they can help you enforce or recover the wages that you should have been paid. As an employee, you're also entitled to receive at least minimum wage. You're often entitled to overtime. There are types of employment that are exempt from that, but that's where overtime comes from, the employment relationship. Um, and there are other incidental issues. For instance, your employer should be paying payroll taxes, and money would be paid into your Social Security for the time that you're working.
So to
So,
summarize that, the big distinction is then that employees basically have more systems in place for remedies, like the Texas Workforce Commission. They can make a wage and hour claim through the Department of Labor. And so what we're going to address today, right, is the all the other people who are usually the creatives. Go ahead. I just want to
oh
make sure
no,
that's clear. Um, so if you can find some way to classify yourself as an employee, you may have more rights.
yes, you're better off being an employee. And if there's any question of in your mind whether or not you are one, I would say, and you have a dispute with somebody who hasn't paid you, I'd say, don't be reluctant to go ahead and file a claim with like the Texas Workforce Commission because you lose nothing by making the attempt.
And so for the Texas Workforce Commission, there's a time frame during which you must make your request, right? It's 180 days, I think.
Yeah, actually, that's a good point. I believe that that is correct.
So if you feel that you might possibly have, if you're getting a regular wage for the regular gig and you were expecting a paycheck and maybe a venue shuts down, or someone who hired you for graphic design doesn't just stops paying you all of a sudden, you can file a claim under a payday law, or I can't remember what it's called. It's a payday law for 180 days from when the last payment was due.
Mhm.
So that's something to keep in mind. It's better safe than sorry to go ahead and file it, so that that 180 days doesn't run out.
And I'll just throw in there that if for some reason you miss that deadline, you don't lose your remedies. Like you can still file a lawsuit under the Fair Labor Standards Act for 2 years, and employment relationships are also considered a contract. Statute of limitations on that is 4 years. So, it would be ideal to file your claim within 180 days in order to get help from TWC. But you still have remedies even if you miss that.
Great. And so what if their contract says, does it matter what their contract says, what their employment contract says, like that they're an independent contractor?
Yeah, you can't negotiate your status away. It's the what can happen is a contract can outline terms, sort of memorialize the nature of your relationship to create a piece of evidence later for what the nature of the relationship is. So, for instance, if I if that plumber showed up and I could sign a piece of paper saying, confirming the details that he brought his own tools and that I'm only hiring him for this one thing, etc. But, if I employed a maintenance person and made them sign that contract, well, they may have signed it, but that doesn't make the facts true. And so it has some limited value in terms of providing some evidence about what was actually going on. But if it's not accurate, a person can still put on facts to demonstrate that they were in fact an employee.
And
And
there
when I
may
say put on facts, I mean like if you're in front of a TWC administrator or if you file a lawsuit in small claims court or something, you can still tell that decision maker like, yes, I signed this, but this isn't true.
and there may also be penalties for wrongfully classifying people, correct?
Yes, not penalties that give rise to like a private cause of action, but they can certainly be punished by the government for that. It's kind of like talking about criminal law. Like you can do things that'll get you into trouble. Doesn't mean that somebody can sue you for it necessarily. But yeah, there are penalties for misclassifying your employees.
Okay.
Guys,
So
So you can narc on them.
go ahead, Pat.
well, I was going to add, I don't know if we want to save questions for the very end of the webinar today. We do have one question that's come up if we want to address that now that's related. Would you like me to offer that now?
Sure.
Um,
For the other sections, let's go ahead and wait until the end
sure
because we
enough. Yeah,
get to the
yeah,
small
definitely.
part.
Certainly. So this question over the TWC claim filing, What if the client or venue is in another state from the one the contractor lives in, if they are not in Texas?
You know the answer to that, Brian?
Yeah, I was just looking it up. So let me start by just talking about like lawsuits, and then graduate into TWC. So normally to bring a lawsuit against somebody in Texas, they have to have like a meaningful connection to Texas. And that's rooted in due process, basic fairness. If someone lives in Seattle, they shouldn't have to deal with a lawsuit in Texas, right? Exceptions are if they come to Texas and do something bad here, then yeah, they are subjecting themselves to Texas's jurisdiction. And with employment, that is functionally the same thing. Um, if you are elsewhere, but then you employ somebody in Texas, you are subjecting yourself to claims in Texas and get a little bit fuzzy in terms of whether or not they've actually filed, or, well, I won't get into the weeds. You would have a right to bring a claim. Similarly, TWC does have the ability to bring claims so long as the work was brought in Texas. Um, their policy about what sort of claims they may accept could change. So keep that in mind. I mean, that might be a moving target. You'd want to go back to the website to confirm. Just like an attorney may decide, oh, I'm not practicing this area of law anymore. I'm just going to focus on this. But that due process restriction, the constitutional protection against not being sued in random states you have no connection to, um, that wouldn't be an issue so long as you're performing the work in Texas.
So just to put it in everyone's mind that the legal term for that is jurisdiction. So if you see that's what it means. It's like there can be subject matter jurisdiction, there can be long arm jurisdiction over location, geographic, basically. So it basically means can you sue here or where do you need to sue? And that may come up later too. So before we move on from employee independent contractor, the upshot is try to get yourself classified as an employee if you can. You'll have more remedies. But also, if you can't, this can change the nature of any sort of artistic creation you made, whether you were an employee or a contractor. And again, that's not what we're covering here, but I'll just put in your mind that there is now kind of a small claims court for copyright disputes. Previously, it was almost impossible to get into court and represent yourself, but now there's something called the Copyright Claims Board. It's a few years in, and it really kind of follows the small claims model. And if you're interested in that, we have a webinar available at our YouTube site. Okay. So let's talk about what kind of situations you might find yourself in where you might be able to take matters into your own hands. And that is going to kind of be determined by what kind of cases, the courts can hear. So for our purposes, it looks like from the people who signed up, it looks like what we're mainly dealing with is clients who haven't paid. We have people who have lost, damaged, or stolen equipment. Um, and we have freelancers who just aren't able to collect on a contract. So, Brian, why don't you talk about what these people can do?
Sure. Well, I mean, the starting point here is that for most legal issues that go to court, you do have a right to represent yourself if you choose to. The limited exceptions are if you're suing on behalf of like a corporation, which I suppose if you in your business are working through an LLC, that could be an issue. And then certain things like probating estates and things like that. Absent that, you are entitled to represent yourself in court. And I'll just say with the incorporation issue, you're still entitled to represent yourself. But if the actual aggrieved legal entity is an LLC, then you would be attempting to represent the LLC, which you're not allowed to do unless you're an attorney. Um, Beyond that, I think it goes to the level of complexity of the case and probably the stakes involved. So um, they're justices of the peace in Texas, accept civil cases. They do a number of things, but one of which is they can hear civil lawsuits. It used to be that there were separate small claims courts, like actual different venues. Those were folded into a justice of the peace's jurisdiction now. So that's part of what they preside over, small claims. And that's defined as most lawsuits where the value or the damage involved is at $20,000 or below. They can't do injunctive relief. So if you need like a court order to like for somebody to do something aside from give you money, JP can't do that for the most part. They do have some ability to do that when it comes to like landlord tenant rights, but that's not what we're talking about. They also subject matter wise, like they don't hear family law cases. They don't, like that sort of thing. But for any sort of lawsuit where you have been injured or your property has been stolen or damaged or a contract has been breached, that falls squarely within their jurisdiction. The advantage to you of small claims court versus other venues is that a number of the sort of esoteric, opaque rules that would trip up a person in other settings are not used in small claims court. And when I say that, that means almost all of the rules of civil procedure, not entirely. There's a much smaller subset that's applicable to small claims court, but it's a shorter list and it's very simple stuff. It's hard to trip over. And also the rules of evidence pretty much go entirely out the door. The judge has some discretion to apply them in limited situations if they choose to. My experience is that JPs don't bother with that. And so there are a number of rules of evidence that would trip up a person in terms of, getting the judge to consider a document as a piece of evidence.
Hearsay,
Or,
an example.
sure. So documents are a big one. Normally, if you have a receipt or an invoice or something like that, in most court settings, it can be difficult to introduce that as evidence because it's considered a form of hearsay. And I'd be happy to explain that to you if anyone wants to know more about
Don't
hearsay.
want to know.
But I'll just skip past that and say it's not a thing in JP court. And so it's a lot easier to introduce documents, and it's a lot easier to talk about or to present to the judge information about conversations and so forth that happened outside of the courtroom. Conversely, if you ever have a matter like a family law case, like a child custody thing or something like that, it does become really important to have an attorney because these are rules that they're not rocket science. Trust me, there are plenty of dumb attorneys who get by just fine, but they're not intuitive. And so it's easy to just not be aware that it's a requirement if you haven't received formal legal training. But in any event, yeah, if you're dealing with an issue that's under $20,000, you can probably get by just fine in small claims court, assuming that you're, um, you know, reasonably smart and that you're motivated enough to kind of package it up and take it to the judge.
So, using examples we've probably all seen before, like regular civil court would be the district court, and that would be more something like, a formal trial, like the OJ trial, even though that was kind of crazy, versus something like Judge Judy, where you're basically talking to a person, telling your story.
Yeah, no, yeah, that's a pretty good example of the difference. I'd say most JPs are a lot more polite than Judge Judy, but yeah.
Yeah. And you don't have to be a lawyer to be a JP, isn't that right?
That is true, and that can really cut both ways. In Travis County, and I think now in Williamson County, all of the JPs are attorneys, um, which is helpful. Um, Outside of major municipal areas, it's pretty common to have JPs who are not attorneys. But that kind of feeds into the formal rules not being applied. You'll
Yeah.
get a more sort of common sense approach to deciding what the outcome of the dispute should be.
So what that means for us is basically this is more kind of person to person, transaction or negotiation where they're not going to trip you up on technicalities. And that's why the JP court is more accessible, um, which is great for smaller disputes. Awesome. Okay. And Pat, do you have any questions? Like, do you think your members have any questions about that?
Well, I was simply going to say that I think we have a couple of people maybe who have not received the Zoom link to the meeting yet.
Okay.
There's a Chris Laurel that's waiting in the wings. for that link. But beyond that, yeah, I think I could certainly save them till the end, or they're somewhat related to what we're talking about now, if we want to.
If they're very general, you can see them too, Brian, right?
Yeah.
Um, I mean,
Well,
there aren't any questions in the chat.
this is actually for me. I
Oh,
think
they're
when
chatting Pat. That's what's happening.
right, right. When we talk about most of our musicians, I think that we serve, we're talking about generally independent contractors. When we talk about, the definitions here, uh, if someone has an LLC or a DBA as a musician, would they then be considered, and I know this is a very general question, but would they then be considered an employee of that LLC or DBA, or still just be considered an independent contractor?
And I,
Okay, I'm going to push back on the. Oh, Angela, did you want to answer
I
that?
think a simple way to answer that is it doesn't really matter for our purposes because you'd basically be suing yourself. Like
Right.
it's your relationship to the person who owes you money that matters, not your relationship to your LLC. Is that
That makes sense, certainly.
okay?
Thank you.
I agree.
Yeah.
So basically, are you an employee? That's a great question, though, because we see it a lot.
Mhm.
Are you an employee as an individual of this company or this person, or have they hired your company as a contractor? That's
Exactly.
the distinction, right? And
Yep.
so if you can kind of show that they were actually dealing with you as a person, um, you would have more remedies through government agencies to take up the action for you and not have to kind of just do it all yourself. So and still in that case, you would still want to try to be classified as an employee. Can you see any situation where an LLC would have those rights? I don't think so.
No, but I would go a step further and say that under the law, there's also a theory of joint employment where depending on the circumstances, you can be the employee of more than one entity at a time. And you can think about that in the context of, say, like a general contractor and subcontractors. This comes up a lot in construction where you have someone who's building a building and then they hire a subcontractor to do the wiring or something. It comes up in construction because if they are genuinely a subcontractor and they just show up and do their work independently, then that cuts off the employment relationship between the worker and the general contractor, which can become important. But if they hire the subcontractor, then the guys come out and the general contractor's on site and starts treating them like employees, then the general contractor can be treated under the law for purposes of a lawsuit as a joint employer. How does that apply here? Well, I'd say, if somebody hires your LLC and then you show up and they are treating you like an employee, meaning like, the lack of control, giving you hours, um, kind of micromanaging the way you do things, that sort of thing, then I think you would have remedies through against them through that theory of joint employment, even if legally you can be considered to be an employee of your LLC as well.
So, more specifically with our audience, it might apply to a band member.
Uh, yeah, potentially. I mean, I think my understanding of the music industry is that, I mean, a lot of things are episodic. You're not promised like future employment. There's not a lot of control aside from saying be here at 9, that sort of thing. So a lot of those probably are practically going to be independent contractor relationships. Um, but yeah, I mean, in theory, if you have somebody who has, gotten that gig, like the band leader who like hires a drummer and says, be here at this time and do this and do that, I mean, if that's your question, that within that context, there could be an employer-employee relationship within the band. Um,
And where we see this causing the most problems is in the area of work for hire, like graphic designers, for example,
okay,
um,
okay.
or session musicians, perhaps. There are a lot of times when people are told they're contractors, maybe so that they can avoid giving them health insurance or whatever. But there are other legal rights that are implicated by the classifications, and basically there are ways to kind of shoehorn your way one way or the other, depending on what side you're on, based on, what you did at work every day, how you did it, and who directed you. It's something to keep in mind. So, especially applicable for our designers.
Yeah. It's hard to give people a hardline rule because there isn't a hardline rule. Like it's a test with elements. The major takeaway should be that the more control they exercise over how you do the work, the more likely it is you'd be treated as an employee. So if you're a graphic designer and you're told like, hey, I need you to put together a brochure and I need it by Friday, more likely to be an independent contractor. But if you get a gig and they say like, yeah, we need you to show up at the WeWork office 3 days a week, we need you here, we need you to come to these meetings, like we're gonna like go back and forth with you over the content, it becomes increasingly likely that a court would agree that you were an employee.
Okay. So, one of the common misconceptions, I think, oops, that I've seen is that, well, I'm not sure that I can do anything about this because it was a handshake deal,
Mm.
or,
Mhm.
this is the way we've always done it. We never wrote it down. Um, so I don't think I can sue. I don't think I have any remedies. Can you tell us what a contract is? What can be construed a contract and what kind of things are enforceable in court?
Yes. I mean, at a baseline, any agreement to do something in exchange for money is a contract. It's
So
really it's broader than that. This is like laws. I'm sorry, Angela.
no, this is going to cover, I just want to make clear, this is going to cover not just employment, but also sales of items. So if you sell things, you have a contract with your buyer. You have a sales contract, whether or not you signed anything specifically. If you are purchasing a service or you've purchased something or rented something, that is a contract, even though you haven't necessarily signed something. So keeping that in mind, this applies to all situations here.
I do want to put on your radar that there are a few very limited examples where you do need a written contract. It's not going to be the majority of what you're talking about. If you ever Google this later, Google statute of frauds. Um, but uh, contracts for real estate, leases of real estate, and now real estate's like the ground and things that are bolted into the ground. Vehicle or anything you can move around, it's not real estate, it's personal property. But a lease for real estate that's longer than a year, contracts that cannot be performed in 1 year, like acknowledged in the contract that there's no way to do it within 1 year. Um, a few other things, contracts for the sale of goods of $500 or more. Those have to be in writing in order to be enforceable, which primarily means if it doesn't happen and someone wants to sue you because it didn't happen, it had to be in writing. Um, I want to focus in for just a moment on the contract of sale for 500 of goods for $500 or more. If you have an agreement with somebody and you're like, I've got an antique xylophone and it's worth $1,000 or whatever, and you give it to them and they don't pay you, you still have recourse against them. But if you make an agreement and then you change your mind, they're not going to be able to sue you and say, "Here's my $1,000. Like, give me the xylophone." Um, so And then, so there are a few exceptions, and I only say that because I cut my teeth on the law during the foreclosure crisis, and a lot of people got screwed over by verbal promises from lenders that weren't in writing. So I don't want you to not know about that. But for the most part, any agreement, whether it's written down or not, is enforceable. The only trick can be proving what the terms were. Oh, and in terms of what if it's a writing or not, it doesn't have to be a formal written contract, where the devil shows up and the paper appears and your pen with the blood on it appears. Um, a writing is a writing if it's an email or if it's a text message exchange or anything like that too.
That, if I may, that one comes up a lot with our musician community. When we talk about performance agreements and things like that, so often musicians ask that very question that, well, all I have is an email exchange with the promoter, and does that constitute a contract? I'll also say, Brian, that may have seemed like a random addition to talk about xylophones, but we do have a professional xylophone player in the room with us today, Aaron.
Oh, okay.
Yeah.
We also got a
Well,
question about a
bravo.
xylophone that's missing. So,
Oh, okay. So I was just conjuring an instrument out of the air. I wasn't making reference to anyone's specific
Never know.
situation.
You never know.
You never know.
So basically, I guess one thing that's important to understand is that a contract, like Brian said, is any sort of agreement to do something for money or to sell something for money.
Mhm.
Um, but a court doesn't need to see a formal writing. They can also judge based on behavior, right?
Sure.
Like, I created this website and this person that I don't know, that I've never met, says that, oh, I thought they were just doing it for free. A court is not going to buy that. They're going to assume that I acted in reliance that I would be paid. So that's how gray it can get.
Yeah, and that building off that, because that's absolutely true, of course. Um, you can also have recourse if you haven't specifically agreed to all of the terms of a contract. You mentioned handshake deals, things like that. Sometimes people will make an agreement to do work without like the exact price necessarily being specified. And that can be actually litigating that becomes a little bit complex, but suffice it to say that doesn't mean that you have agreed to do it for free. A judge can be convinced that you agree to do it for money and that it's traditionally X rate because everyone charges this rate for that thing or something like that. So you can point to like customary rates, or if you've done the same thing for somebody before and they always paid you like a fixed amount, like a judge could infer from that that you both understood that it was going to be the same amount this follow-up time. And so, you know, we're getting into the again the range of the devil being in the details, but even without like necessarily agreeing to a specific amount, you still have remedies and a judge can still decide that it was worth a certain amount.
So if you don't have a contract or your contract is vague, or maybe you find out later that you weren't exactly agreeing to the same thing, like you mentioned, is that a breach?
It can be. I mean, and we're getting into the realm of the facts where a judge could go either way on it. So it's going to depend on what a judge believes. But I mean, back to your point of like making a website or something like that, most people aren't doing that for free for strangers. I mean, that belies common sense. Judges are human beings, despite some evidence to the contrary. So, it's a joke. They're going to exercise common sense. Whether or not you've breached, I mean, it's really whether there's been a breach. It really depends on the circumstances. One thing to tell you all about, and this is as good a time as any, is that with any agreement, when you're talking about a breach, what you're really talking about is a material breach. And so if you say, I'm going to show up at 9 p.m. to do the thing, and you show up at 9:05, that's probably not a breach. Material, in other words, means like important, you know? If I agree to sell you a basket of apples and one of them has a blemish on it or something, that probably doesn't matter. If I agree to sell you a basket of apples and I show up and they're all rotten, that could be kind of a big deal. And so there's not really a bright line in terms of what's material or what's not. It's one of those things that sits on a spectrum. But to your point, Angela, I mean, if somebody hires you to come out and play a gig and, they say, oh yeah, and there's free water, and you show up and there's not that much free water. I don't, I'm not sure that that's going to be a material breach, and it'd be hard to put a dollar value on that too.
That's also
Um,
a segue to the next point. But before we move on to that, I want
okay.
to ask about a question that's very common with graphic designers, for example. What if they hire you to do something and they say they don't like your work? Like, what if they're
Oh,
saying that you haven't performed to the level that the contract required?
Comes up in the music community as well, sir.
well, you know, in a well-planned situation, that detail would be governed by a written contract, and the parties would have negotiated ahead of time about what the quality of service needed to be and whether or not that was actually an issue. I mean, that comes up in legal practice sometimes too. People hire you to do a case and then the case doesn't succeed. They're like, well, I shouldn't have to pay you because the judge ruled that blah, 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 blah. And my contracts say, no, you're paying me for my time and things that I can control. Um, you, you know, you're not paying me based on the outcome. And so, in this situation where there's no contract, I mean, I'd say in general, it's probably going to be understood that you're being paid for your time. And in order to, I mean, in order to not pay you, I think the person on the other side would have to demonstrate that your performance, no, I mean, your literal performance, if it's music, or performance in terms of producing a piece of graphic art was so deficient that it was, the rotten bag of apples. Like, it's not just that they didn't like the color palette that you chose. Like, you showed up and gave them garbage instead of an actual project. Um, so for the most part, I'd say even if they're not like super happy with what you did, they still need to pay you.
So that's a great segue to the next part. And one of the ways to determine whether the breach was material is what were their damages? Basically, how much is it going to cost to fix this?
Mhm.
So go ahead and we can go and start talking about damages
So
and what you can sue for.
before we do that, we do have a question in the chat. And I'm going to read it out so that people watching the recording later know what it was. What if money never changed hands for a service that was agreed upon but never done? I.e., service provider agreed verbally to provide a service but didn't take payment up front, took an item to be serviced, did not perform the service, and kept the item and never billed. Um, well, the one thing that stands out to me is kept the item. So okay, took an item, kept the item. So the service is related to the item, like a repair or something. Um, in general, let's say start with something more generic. If I hire somebody to paint my house and they're supposed to do it on Saturday and then they don't show up, and then Monday I'm like, WTF, my house was supposed to be painted. It's still so ugly though. Um, I probably didn't suffer any actual damage because I didn't pay them and they didn't do the work, and I can just pay someone else to do it, right? In contrast, if I pay somebody to harvest my crop and put it in the barn, and they don't do it, and we did it with the understanding that a hailstorm was coming next week, and then the hailstorm comes and destroys my crop. I relied on that person to do the thing, and they didn't do it. Now my crop's destroyed. Um, so, that would be a material breach where you could sue them for that. I kind of like to now that there's so much going on with like the multiverse and media, it's almost easier to explain it to people that way without being like a super nerd. So yeah, like in a fork in reality where something went wrong, what would it take to bring you back to the main timeline? If somebody busts out your window, the damage is the cost to replace the window. If somebody breaks your toe and as a result you're not able to go into work for a week, then your damage would be the medical bills and your lost wages. What do you need to come back to the main timeline? Um, okay, so with the service, if somebody if I take my car to the mechanic and the mechanic a week later is like, sorry, I shouldn't have taken this in. I was just too busy. I can't deal with this. I probably don't have damages. Like, I mean, unless I was relying on that somehow and it was foreseeable that I was going to, like, I don't know. After that week, Trump passes a law that says cars can no longer be repaired. Um, eh, you know, Something crazy like that. You may not have damages for that. Um, Now, if they keep your car for a year and you're paying for a rental car that entire time, then yeah, maybe. Um, if they keep your car, that's kind of a big problem. Because if I take my car to the mechanic, I'm not giving them my car.
Mm.
I'm allowing them to have possession of my car for a limited time with the understanding that I'm taking the darn thing back. Um,
May I reframe this?
so yes,
So I think we need to back it up a little because I think we need to distinguish first that this might not be a contract issue, right? The dominant claim here would then be theft or conversion, right? But the
could be
reason that
both.
matters is because there are different statutes of limitations between the two claims.
Yeah, well, I mean, in a service context, I think it could be construed as both. And
Mhm.
so, background for that, legally speaking, you could have a number of causes of action for something, for the same fact pattern. That's allowed under the law. It could be, well, like here, it could be a tort, conversion of property. As Angela, I think you mentioned today, certainly in prep, conversion is like a civil claim for theft. But not only that, I mean, if somebody demolishes my car, you know, whatever, with a sledgehammer. That's still conversion. It's denying me my property. If somebody's dog kills a cow that I own, that can also be litigated as conversion because the cow is property and I don't have it anymore because your dog killed it. Um, so that's one. And then, I think it is a breach of contract. I mean, you'd have to construe the contract as not merely being the service, but also returning the thing to you. But I think there's a fairly good argument there. The reason why it matters, most of the time with different causes of action, it doesn't increase the dollar value of what you can recover. Your harm is your harm, whether you construe it as a tort or a breach of contract, assuming you can lump the same harm into the thing. So the value of your car, for instance. Um, I don't get to double dip just because I have two causes of action. There's some limited exceptions, like some consumer rights statutes where you can like treble your damages if you can show that a person's acted in bad faith, and in that case, that's worth going after. But between those two, the major difference, and sorry I've meandered so much, the major difference is the statute of limitations. In
I love,
brief, a statute of limitations is a, sorry.
yeah, I was going to say, I love that you went down the road of the multiverse, but
Ah, okay. Well, so good because that's the sacred timeline that we're stuck on.
narrow and
Um,
with
We're hoping
the
so.
audience we have here. And so I'm just going to try to summarize because this is the part where I
oh,
was saying that, you give a lot of information because you know so much about this stuff. But okay, so in law school, they tell us the way that you decide what to argue is first you try to argue the law, the black letter law. Like, what does the law say? Was it broken? Second, if you don't have the law on your side, you argue the facts. Like, what did the facts say? I did this, so this must be true. And third, if none of those things work, you argue motion. So the strongest argument is always arguing the black letter law. Well, someone took your thing, you don't have your thing, it's theft. There's a law against theft. So criminal law will always be the strongest thing. Now, the reality is, of course, that the police are going to say, well, this is a civil matter, or this isn't theft, this is a contract issue. So, no big deal. Even though you in your mind and everybody knows this is actually theft, um, the police, it's effectively worthless because the police won't enforce it, right? So a lot of times we see people stop there. They see the police as the only accessible authority, but that's not true. If you can't go under the black letter law of the criminal law, you can argue the facts, which is that, you have lost use of this thing, and that is conversion, which is civil, um, meaning that you can sue for money to recover from whatever damages, and by damages we mean money lost that you have suffered. And what those damages would be is firstly the value of the thing. Secondly, whatever money you might have made or lost from not having that thing for the time period that you had it. And I'm sure, Brian, you can think of many more.
Yeah, and if I may just compliment what you're saying there, Angela, you know, if the scenario, with our musicians is that, say, for instance, they have a touring van, we'll just call it, that they drop off for repair,
mm,
the because the touring van is out of commission and they don't, maybe a year goes by and they haven't had the touring van returned, and then there's a loss of wages because they aren't able to utilize this crucial piece of equipment at that point in time. And then even possibly they might find that the touring van has been listed for sale and still somewhere else and still not returned to them. Um, does that help build more of a case in that instance, Brian?
yes. I mean, there are counter arguments that could be raised, and I'm going to resist bringing them up because I think that's going to be another rabbit hole. But yeah, certainly, any financial loss that is closely tied to not having that piece of property could a judge could award you damages to compensate you or reimburse you for that loss. And so, in not over analyzing this, I think, just skipping forward a little bit in terms of the practicality of bringing a lawsuit. I think what you do is you want to go into court with arguments that are as stacked in your favor as possible. arguments that are true and that pass the blush test. Like, you don't want to say things that are, just really off the wall. But like in this context, I mean, an argument could be made either way about whether that missed work is part of the value of what you lost. You shouldn't second guess yourself, though. You should go into the judge and make the argument that that is absolutely one of my losses, and see what happens.
Excellent. I'll also add here, I think we have a comment from Aaron. It could be worth mentioning here that the American Federation of Musicians bylaws specify written contracts for all services based on centuries of entertainment contract history. Employers generally are able to spend much more on legal costs than artists can spend.
I saw that. I didn't understand the part about specifying written contracts. Does that mean that the American Federation of Musicians bylaws requires employers to execute written contracts with musicians?
I'll let Aaron answer that in the chat. And I guess this is also a good moment to just say that, when
Ah,
possible, I said. And then,
gotcha.
with performance, with anything, we really want to stress to our musician community to always use contracts. It's just, it clears up so many headaches later on. I know that the Texas Music Office has a template that's easy to download. I believe that the union also has a template. But we just really want to stress to all musicians to try to employ contracts whenever you can for performances. If you're doing any sort of licensing agreement for your music or entering into any sort of agreement with a label or anything like that, contracts, please use contracts.
And for other types of artists, what TALA sees a lot is disagreements over whether work has been completed or performed to satisfaction. And so, beyond a contract, we always promote if you can get a deposit or get payments for increments of work done, and very clear markers for who and how, what decides whether that work has been performed, and specific dates that payments are due, so that you don't complete a whole project before you realize someone's not going to pay you. And I think that applies to anything where you are creating a product where the success of the product is going to be, I guess, subjective. Like, what if they say, I just don't like it, you know? So, you want to make sure that you get whatever deposit you can, because even before you've put anything in code for a website or written something on paper for an article, there is kind of the design or thought phase or the planning phase, the meeting with the client phase. If you're not being salaried or paid hourly for your time, you need to make sure you get compensated for that in the form of a non-refundable deposit. And in that contract, you need to make clear, that this is non-refundable. I don't care what happens next. I've already spent this time with you. This is non-refundable. And so you have those increments so that the whole contract can't get thrown out. You just throw out the last part, maybe the last installment or whatever.
Absolutely.
That's extremely prudent. It's
So,
very, it's,
go ahead.
no, go ahead. I'm sorry. No, go ahead.
So, I mean, one of the things that we really advocate is that you get an attorney involved before there's a dispute, if you're in a situation that could possibly end in a dispute. You know, band agreements, any sort of work for hire situation, because there is help available, through TALA. Contract review cases are not that expensive if you don't qualify for teleservices. I'm sure, Brian, you probably offer some, and you do work for hire stuff, agreements. You look at them all the time. Um, these things are not that expensive, and it'll save you so much heartache and money and time in the future because there's not a lot of help for litigation.
Yeah, yeah. Um, I agree with that. I mean, even if your rights are clear cut, the process of extracting money from somebody is time consuming and often expensive. So cash in hand is much better. Um, Very clear contracts, super important, super helpful. Um, the one thing I wanted to add to that too is be mindful again that anything in writing can be construed in a contract. And so, although the ideal is to have a detailed, separate written contract, and don't abandon that, although that's the ideal, if you're in a situation where it's like a quick transaction and you don't plausibly think you can get someone to wrap their head around doing that in the time available, and I don't know exactly what that would be, but like if somebody's like, come out and play for 2 hours, I'll give you $200 or $300, and it's a very kind of quick thing. It wouldn't be a bad idea to memorialize the basic terms of that, the key terms, in like a text message and be like, my understanding is this. Please confirm.
Absolutely.
Um,
Send an email follow up saying, this is what we talked about today. This is how I understand it.
yeah. So, I mean, in an ideal world, you'd have a detailed contract and it'd go through DocuSign. Don't abandon it for the easy approach. But if that's not possible, I mean, in theory, something as simple as like a text message with them thumbs upping it is something you could still take to a judge.
Okay, so now that I'm looking at the time, and so we've got 20 minutes to cover our small claims portion. Um, so now that we've determined that there is a breach, there's something we can sue for, we're within either our 2 year or 4 year statute of limitations. What do you do next? What do you do to set yourself up to be in a good position to go to court?
Well, I mean, the clue that I have from this slide is send a demand letter. Um,
Yes,
a
document.
demand letter.
Go
Sorry,
ahead.
I missed what you said. Document something.
Document, you make sure that your requests for payments are documented, right?
Yeah. Yeah. So, I mean, for the most part, most lawsuits, demand letters are not strictly required before you file suit. However, it is extremely prudent to give it a shot because a lot of people are not interested in going through the hassle of litigation. And if they are reasonably certain that you're going to file a lawsuit against them, it can change the incentive structure around them. Like if they owe you $200, it's easy to like ghost you on texts. That's the easy thing. If they're like, oh, I'm about to have to spend like 12 hours of my time and like $2,000 to like fight this small claims case, all of a sudden the easier option is just to pay you the $200. And so, you never know if a demand letter is going to work, but it's quick and easy to send one, and sometimes they do. So it's worth a shot.
So a lot of
Um,
people think that demand letters can only come from attorneys. Is that true?
nope,
Does it have
nope.
any legal force or bearing? If it is it more legal, does something have to happen if it comes from an attorney?
No, I mean, I think it can be scarier to some audiences if they get something from an attorney, but it's really just optics.
That's right.
And I mean,
So
I guess there's a basic credibility thing. Like most attorneys are not going to send a demand that's like complete bullshit because, pardon my language, but our credibility is kind of important to us. And so generally well, although that's not always true, I've seen some lawyers send some demand letters that are complete bullshit. So it adds some credibility for some audiences, but it's really just optics.
just very briefly, I know in some jurisdictions, there have been rulings that you should not be writing a demand letter if you don't actually intend to sue. So you
But
actually have to
that's
show that if you are an attorney, that you are going to take this to court. It's not just an empty threat. So sometimes it might actually be hard to get an attorney to write a demand letter for you. And I bring that up because in pro bono, when people aren't paying for the demand letter, they will ask us to write demand letters for, less than they would if they were paying us to write it.
okay. Uh, well, I mean, I guess, yeah, I wouldn't encourage you to send out frivolous demand letters, particularly if it's for something where you don't really have a claim. If you
And
have
so,
an, sorry.
go ahead.
Well, I was just gonna say, I mean, I mean, your observation about some jurisdictions making that ruling kind of surprises me. Because I can say, like, under the Fair Debt Collection Practices Act, one of the restrictions that creditors have, which nobody collecting their own debt is considered a creditor under federal law, it's third-party debt collectors. They're not allowed to make threats for litigation if they don't intend to pursue it. that can be difficult to prove, but I mean, I'm sure that there are circumstances where that does come up. It is in the statute. Um, and I could see how a wholly frivolous demand, like that was based on a lie, like you don't like your neighbor, and so you're like, you, I don't know, you destroyed my car when it just isn't true. It's not even remotely true. Your car is fine, or you know that it was something else. I guess that could get you into trouble. Like that could be perceived as like maybe criminal harassment or something like that. But I wouldn't want to if somebody's done something to you and you think that you could take them to court, you think that you might take them to court, I think you're probably pretty safe sending them a demand letter, even if you're not sure that you're going to take the plunge ultimately.
So I would say that if you do have access to an attorney who can assist you with writing a demand letter or reviewing your demand letter, you should try to get that reviewed because there's some really weird legal situations where you can open yourself up to countersuit
Right.
or suit in a different jurisdiction just by sending a demand letter. Basically, their
Hmm.
rule is saying that you sent this letter to this state, that's you agreeing that you can be countersued in that state.
It's too bad that we
Creating
don't
minimum
have.
contacts with the other state.
I was going to say
That's
it's too bad that we don't have two wonderful organizations that provide free or low cost legal services to our creative community. So, yeah.
Um, so demand letters, you had mentioned something very interesting about writing demand letters. So one of the things that's really in demand is do you have a template for a demand letter? We usually say that we don't like using templates because everything is so specific to certain situations. And like I said, you might be opening yourself up to lawsuit if you do things a certain way, even though that's a remote possibility. What do you recommend when someone says, I need to write my own demand letter? What goes in it? How do you do it?
Um, I think it boils down to clarity of communication about what you're complaining about and what you want out of it. I mean, what you'd want to avoid is sending a demand letter saying, I'm really mad that you did this. Make it right. I think for the sake of clarity of communication, you want to identify exactly in detail what your ask is. I mean, and so I think, I mean, and I'll grant you that there are weird situations, and if anyone wants to throw one at me, I'm happy to tailor this advice to a weird situation. But for kind of more common situations, if somebody has your piece of property and you want it back, or if you don't even know if they still have it, the demand letter would be, I left this guitar or this vehicle with you on approximately this date. And if you don't remember the exact date, that's fine, but like September. Um, you haven't, I need you to return it by the end of the week, or its market value is $3,000. I need a check for $3,000 by this date,
Great.
or else I'm going to pursue legal remedies against you. And so, yeah, it's a clearly identified harm, clearly identified remedy. In this case, return the thing or give me its monetary value by a specific date. Um, you're not going to lose your opportunity to sue them if you like leave some ambiguity in there. It's just it's less valuable if you're like, give me $500. You don't specify a date. They're like, I'll give it to you next Tuesday. Happily pay you tomorrow for a hamburger today. You know, um, I mean that's the core thing that I would recommend.
So the way I look at demand letters are sometimes I see them as just a formality when I know that the other person is just kind of throw it in the trash. I see it as a way to document the timeline and kind of produce evidence, right? Like, this is why, we made an agreement on this date, based on these emails or whatever. In your email, you said blah, blah, blah. And then you basically lay out your grounds for a lawsuit, all of the legal requirements that you would need to show your damages and to show the thing that they did wrong. And then, of course, also being very specific about what date you need a remedy and what your remedy is, or this other thing will happen. And, that can then be used as evidence of your demand. That said, back to statute of limitations, right? So some of these situations I've seen, the cases are very old, and the people didn't realize that their stuff was actually stolen, or that the person wasn't going to pay them. Say it's a 2-year job and the final balloon payment or whatever wasn't made, and you don't realize until, however many years later that there's a breach. Um, how can a demand letter and a response to a demand letter affect that? So I'll say what my thought is, that when they respond to the demand letter, that can be construed as a new agreement, right? And a new enforceable
Depending,
agreement starts the 2 years over.
it can, depending on how they respond. Um, I would say in general with statute of limitations issues, I always advise people to be very careful. And when in doubt, get your lawsuit filed before the earliest statute of limitations that could accrue. Because it's a dramatic remedy. You can have a slam dunk case and lose it because you didn't file on time. Um, Depending on how they respond, I mean, that could be construed as a new contract or, well, a novation, which is a new contract. Um, a contract is defined by offer and acceptance of an exchange of things of value. It's super general. And so, a settlement agreement, which, in response to a demand letter could be construed as being the equivalent of a settlement agreement. When I sue somebody, for whatever, they're like, I'll give you $50,000 to end this. The way that the settlement agreement is structured is literally, I will pay you to stop suing me, please. Stop suing me. I don't like it. Don't sue me again for this thing. And in return for that, I'm giving you $50,000. So that's what it is. It's a contract to stop suing them. Um, and if I sign that contract, there's a car, let's say there's a car accident or a wrongful death or something. I sign it and I'm like, sure, I'll dismiss the case. I mean, the prudent thing is not to actually dismiss it until you got cash in hand. But let's say, for the sake of argument, I'm being frivolous that day or cavalier, and I go ahead and dismiss it before I get cash in hand. Well, at that point, they can't just say, "LOL, never mind." Like, I've got a contract. I'm like, I dismissed my case so that you would give me money. That agreement, that settlement is a new contract. I did a thing of value. Give me the money. And so, yeah, depending on how they respond, you could, if your demand is, give me $3,000 by next Friday. And if they respond and say, I'll give you that money, but, it has to be by the end of the month. And then you respond, you're like, deal, sure. Yeah, that could be construed as a new contract. Um, and, even conceivably, that could happen even if your original cause of action had expired. I mean, contracts are enforceable unless they're unconscionable.
Exactly.
And in that, yeah, and I mean, a
So
judge
basically,
could
when
construe
they
it that way.
respond, sorry, when they respond, they could basically be affirming, like, oh, yeah, I know it's been 4 years, but I still owe you this money. I agree. Here, I'm going to pay you. So that's why I always recommend that, you have an attorney look over your demand letter, or help you, write it, because you might still have remedies. You might be writing away remedies. Lots of things can happen in that demand letter. It doesn't take an attorney to write or send one, but if you send one, if you can, have an attorney look at it. Okay. Now the other important thing is, what if they respond and don't give you any money, and you basically decide to wait because you believe them?
Oh, I wouldn't do that.
Yes.
I
What if
mean, yeah,
decide?
don't let them string you along. I mean, there's
Yeah,
a reason why we talk about like drawing lines in the sand, or in this case, like giving them a deadline.
Yeah.
Um, because one of the values of a deadline is it's very clear when the deadline's been passed. You're like, give it to me by this date. And if they respond and say, "Oh, I'll give it to you, but I can't do it by Friday," they need to give you a new date so that it's clear when it's happened. If they don't give you a date, maybe, it could be any time, it could be 6 months from now. Or it might end up being never if they end up stringing you along until your statute of limitations runs out.
exactly. And
So,
that's what I want to
yeah,
make.
always,
Great
Yeah.
point.
Don't let them
Always be
string
clear
you
about
along
what
with
you.
a sob story. If they have a pattern of not paying you in the past and waiting and waiting and waiting, they might just be waiting till you no longer have the ability to sue.
Yeah, and frankly, even if they have a sob story and it's super compelling, that doesn't mean that they can't do a contract with you for when they are going to pay you.
Right,
You
right.
know, if they can't pay you right now because they're I don't know, their house just burned down or their kid has cancer or something, like there could be genuinely compelling reasons that you might find moving. That doesn't mean that they can't execute a contract with you to pay you in a year or 2 years, you know?
Here's an
Um,
interesting addition, guys. What if I guess the business that's supposed to pay you, in this instance, if they filed for bankruptcy or they're bought by another business, would that
mm.
nullify that contract?
Well, it depends on which one of those things happens. So, if one business buys another, if they're literally buying the entity, they consume it, then they do that with all of the legal relationships that that company had for good or for ill.
Okay.
So if that company had accounts receivable, then they're buying the accounts receivable, presumably. Usually, if you're talking about buying businesses, the contracts are like super detailed, so you don't have to like assume anything. But presumably, they'd be buying that, and then it comes with liabilities too. If you buy a business and the business there's still a note on the delivery van or something, you got to keep paying the note, or else the bank's going to come and get it. That's true for liabilities like personal injury. If one of the drivers runs over somebody's leg and then the business employing that driver gets bought up, it may come with that liability. There are ways to try to get out of it. I had a case one time, for just by way of example, where the client was alleging employment discrimination, and then uh, it was at a car dealership, and then the car dealership got bought out. Sort of like the new company was like, we're not buying your business, but we are buying all of your assets and we are going to take over your building. And so legally, that did cut off that claim under state law, but I mean, it didn't help them under Title VII, which is the federal anti-discrimination law. So you can run into some trouble there. It depends on the nature of the contract. If they declare bankruptcy, then that could get you into trouble because, I mean, bankrupt it depends on the type of bankruptcy. If it's a sole proprietor, if they don't have a business entity, then they can declare Chapter 7, Chapter 13, potentially get all of their debts wiped away. If they are a business entity like an LLC, they're probably going to be filing for Chapter 11, which doesn't automatically clear away all debts, but it does allow the debtor to restructure their debts. Or more pointedly, it invites the bankruptcy trustee to decide how to restructure your debts. And what they do is they try to get a situation where a business that's in crippling debt it can never pay gets like a payment structure that it can afford and continue to be in business to pay off as many of the creditors for as much as it can while doing that. So usually the goal is for everyone to get paid something, but I mean also everyone kind of gets a haircut in the process. Um, and so yeah, it can affect things. Bankruptcy is pretty complicated.
So we're at the 10-minute mark from when we're supposed to stop. I'm not sure if we should or can go on 10 extra. Pat, do you want to make that call since we started a little late?
Well, I'm good if you guys are, and certainly I think when we repost this information, it'll be.
Yeah, so I think what we'll do is we'll stop with the substantive information, the program in about 10 minutes, and then whoever wants to stay for questions, so 10 minutes after can do that. And I will also be sending a link to everyone who came in through Austin, Texas musicians for a consultation to see if y'all need more help with demand letters. Because, like I said, there are several specific situations that people had asked us about. And we can help you review if we didn't answer your questions here. But hopefully we have. So we've spent a lot of time covering all but small claims court. And the reason we do that is because most of the stuff actually happens before the small claims court. Hopefully we've given you some information on, what to do before getting there, how things that will help you make a good claim, how to avoid getting there. And for attorneys, we know that most things are settled before this stage, right? They're settled in the um, demand letter stage, somewhere, around there. last resort, what do we do if we're ready to take this to court?
Mhm. Okay, I think I can run through this coherently and relatively quickly.
And we also have your brochure.
So,
Can I send out your brochure too, your little summary?
yeah, yeah, please do. Please do.
And
So I did a brochure. Yeah, I did a pamphlet at recent. Well, I updated it recently, but it'll help walk you all through the process as well. Am I eligible? That's what we've been discussing. Do you have a cause of action? Um, where do I file? Well, let's assume first your employer is here in Texas. Generally, there's a set of rules that go into venue. Usually, the priority is you file where the defendant is. If not there, then sometimes where the harm occurred, if that's a different place. And if you're dealing with somebody who's like transient or just like doesn't have like a fixed place where they are, then you can file where you are. And so if it's a problem with somebody in town and you want to sue them in Justice of the Peace Court, for instance, there are 5 JPs in Travis County, and they each have a separate slice of the county. You just have to know which JP you're dealing with. There is a GIS map you can go online, you can pop an address into it, and it'll show you. There's also always the old school way of simply calling up one of their offices and asking the person at the desk, hey, is this address in your precinct? And they can tell you pretty quickly. Um, if you're dealing with somebody out of state or in a different town, venue becomes more complicated because, of course, travel is time consuming and expensive. And sometimes there are things you can do about it, sometimes there aren't. But I'll leave that for unless somebody has a follow-up question. How much will it cost? Well, it depends on where you're filing. So you're dealing with at least two categories of cost. One is most courts have a filing fee, which is just fee you pay them to get through the door. Um, Often you do have a broad ability to waive that if paying the fee is going to be financially burdensome for you. So there's a standard document, and every clerk who are the record keepers for courts are required to have blank copies of this. It's called a statement of inability to afford court costs. Pretty basic affidavit that asks you what is your income, how much money you have in the bank, and you can also include your expenses, which could be helpful, but it's not strictly required. Um, if you know, and it has to be accepted, and they have to honor it unless somebody turns around and challenges it. So, with my clients, I mean, we go up to 400% of the poverty guideline. I really file one for everyone, unless it's unless it would embarrass me for somebody to see that I filed it. And I'm hard to embarrass. Um, you can pretty much get that waived. Now, what is the baseline fee if you don't want to do that? JP Court, I believe that they've increased it to like $139. So you should say it's just shy of 150. That's the filing fee, and it's also actually the service fee. One of the first things that has to happen in a lawsuit when a person is getting sued, they're entitled to formal notice of that. So there's not like a secret court case out there somewhere. And what the law does to give you formal notice is the record keepers, the clerks, will print up what's called a citation, which can mean different things in different contexts. In this context, it's basically a cover sheet that says, hey, Joker, you're getting sued in this court, and you need to make an appearance or file an answer by the date. And it'll be stapled onto the front of the lawsuit, really the petition, but the lawsuit that the other side filed. So you'll get that. If you ever get sued, make sure you file an answer. But reeling it back in, you often have to pay a fee for that thing to get delivered. It has to either be like a constable or a deputy or a licensed process server. In JP court, when you file the 139 or whatever it is, just shy of 150, that pays both for both the filing fee and the service. What do I need to prepare? Well, that's kind of similar to what I need to bring. Um, you need to bring all your proof with you when you go to court. The number one mistake that I've observed people making is when they show up to court, they state a fact, and then they're like, "Oh, but I've got proof of that. It's on my phone. I can show you. It's on my phone." That's an easy mistake to make, but it's an important one, and it's a very damaging one. Judge is probably not going to look at what's on your phone. Um, and part of the reason for it, I mean, there are probably a number of reasons. Part of the reason for that is that when you submit evidence, and evidence is your testimony, but it's also any sort of like physical thing you want to show to the judge, a piece of paper, a video recording, a voice memo, whatever you submit, the court wants to keep a copy of that. And so you need to have those copies with you when you go to court. If it's something you can print, print it. If it's an electronic file, bring a flash drive and that you don't intend to take home with you because they're going to keep the flash drive. If it is something like that, you need to make sure you have a way to play it. Not every courtroom is made the same. They don't all have AV equipment. Best way to figure out what they have is call ahead. Um, if you need to bring a computer, I'll shut up in just a second. If you need to bring a computer to play a video, do that. I mean, they're not going to keep your computer, but I mean, it needs to be on a flash drive that you can find. Angela?
Question about the completeness rule. So there's a completeness rule in other civil courts where if you introduce part of a document, like say you kept a daily journal, the other side has the right to see the whole thing, not just the part you want to enter. Does that apply in JP?
Well, that's a rule of evidence, and so it only applies if the judge cares.
Maybe.
And they don't stand on a lot of technicalities at JP courts. So I mean, I think what you can count on is if the judge thinks you're trying to hoodwink them by giving them a very curated, selective version of your text messages, where it's only the ones where you look like an angel and oh, there are these big gaps between, then they may cast a jaundiced eye at the whole thing. If it's just a technicality and you bring like the contract, but you're missing a couple of pages off the back that were just boilerplate, they're a lot less likely to care. So just don't lie to the judge. Don't try to hoodwink them, and you should be fine. Um,
The way that
and
this
then
is
are the
Sorry, the way that this has come up for us in the past is when people create documentation, when we advise them to create documentation, like write down in journals what happened on what date. Sometimes people write it in a journal with a lot of other stuff that they don't want to necessarily become part of a court's public document to be used in other lawsuits later. So just make sure that when you document, you're keeping it in a separate place, a new place, so you might, you don't weirdly get called to submit the whole thing because there might be other stuff
yep.
in there you don't want them to see.
I think that is very astute. I agree.
Okay, go ahead.
And
Sorry.
then, are there any resources to help me? Yes, let's run through it. So, if you're doing it all on your own, every JP should have at their front desk, and I think virtually all of them, if not all of them, have it on their website, a basic template petition. So you don't have to figure out what they look like. It's a form you can fill out. You name the parties and basic information. That's got a big block where they're like, okay, and then what the hell's going on? So you write your general description of what happened. There's not a whole lot of magic that comes into what you have to put in a petition. You do need to be clear with them about what happened and why you feel aggrieved. I'm not one of these people that's like evangelizing for AI or ChatGPT or that sort of thing. But this is one instance where it is it is a good resource for turning a long story into a concise summary. And so if you're not sure, you can always fire up ChatGPT, tell it the whole story, and say, summarize this in 200 words for me, please. More often than not, it does a pretty good job. Um, don't accept ChatGPT's legal advice, though. That's often wrong. Um, but it's kind of like hiring somebody who majored in English. Like they may or may not know anything, but they write good. Um, that's my view on AI. So that's one. Two, we do have the pamphlet guide that Angela mentioned that I created. It has some value. You can put it together. TexasLawHelp.org is a reputable website that has a lot of good information on it. Most of the time, I steer people away from websites like Rocket Lawyer or whatever. The problem with them is that the stuff they have may or may not be good, and unfortunately, you sort of have to be an attorney to know the difference, and that kind of belies the purpose of using one of those websites. And part of the reason is that a lot of them are multi-state. Who knows? Maybe it's great in California. I don't know, but I encourage people not to rely on those. Texas Law Help, though, it's made here in Texas. It's made by a local nonprofit organization, very reputable. I know a lot of the people who work there. They do it close, or do a lot of their work closely with the state Supreme Court. It's legit. So that's a good resource. Austin Community Law Center. Not saying anyone needs to hire us, but we do exist. We do perform services in exchange for remuneration. If you need to hire us for something, you can go to our website, bostoncommunitylawcenter.org, set up a consultation. You can do that through a form. And a lot of times when people come to us for stuff like this, I steer them to an agreement where we just kind of provide high-level advice to kind of keep the fees down. Um, but you could um, always hire us to tackle the full case, depending on what's going on. Um, Also for other legal issues, like if you have a family law thing that comes up, if you're in Travis County, just as an aside, Travis County Law Library does have staff attorneys who can provide some really good guidance on how on a lot of these things. And so, you don't need to pay. I mean, it can be hard to find free or low cost legal assistance services, but they are out there, and it's good to exhaust all of those options before you consider paying through the nose for someone else or some private practice attorney.
I used to work for the organization that does Texas Law Help, and they're awesome. So Brian and I have both been in the poverty law and general public interest law for a very long time. You can always email either of us, and we will point you to the right place. But there are a lot of different things available. For example, in Austin, there is a clinic run by volunteer lawyers. Um, what are they called? VLS, Volunteer Legal
But you
Services?
mean volunteer legal services?
Yes, and so they have a weekly
The
in-person clinic.
branding's pretty on the
Show up,
nose.
and you can show them your petition, you can show them your demand letter, whatever. Just look up VLS Clinic and go there. I know there are also entertainment attorneys, though they might not, I don't know how much they know about JP Court. Uh, but they also, some of them also have free consultation nights. Um, if you email us, we'll direct you. And as far as what Brian was saying about, their remuneration, they charge a fraction for a whole case. They charge a fraction of what one attorney charges per hour. So there are also a lot of different fee structures that you can use. There's something called limited services or assisted pro se. And if you call Lawyer Referral of Central Texas, they can provide you practitioners, a referral to a practitioner who will ghostwrite your documents for you. So limited services means that you have an attorney look over your documents, advise you legally, and maybe draft your documents, but doesn't actually represent you in court. You're responsible for all your own deadlines and what you decide to do next. You drive everything. But again, I'm not aware of anything cheaper than what Brian's organization does as a nonprofit. Um, excuse me. And of course, there's TALA if you are in the stages before litigation. So, the upshot of that is just email us. There's a contact form on Austin Community Law Center site. So you would just go to there and you can reach them. I answered this account. So, oh, sorry. So that's me in that last screen that we can no longer see. Okay. Um, or attorney at talarts.org will also work. And we will always direct you to the right place. I think, is this a good time to stop the recording for questions? Ron, are you there? Just affirm that you're there, Ron, and paying attention. Otherwise, we'll just be
I
recording.
am. And do you want me to stop
Okay.
it?
Okay. Well, I just want to thank everybody for coming. Once again, just email us. We'll get you to the right place. No one's trying to, have you pay for services in the seminar. That's not our primary objective. So